Okay, we're live on YouTube.
All right. Welcome, everyone. I'm going to go ahead and call the September 1st, 2020 Oxford City Council work session to order. Ms. Eaton, will you please call the roll?
Mr. Bracken?
Here.
Mr. Ellerby?
Here.
Mr. Prithridge?
Here.
Mr. Snavely?
I'm here.
Ms. Southard?
Here.
Ms. Ragu?
Here.
Mayor Smith?
Here. May I have a motion to approve the agenda?
So
So
moved.
moved.
Moved by Mr. Snavely, second by Ms. Southard. So tonight, Councilor Southard. So tonight we are going to be discussing the Ohio Sunshine Laws, and I'm going to try to keep us on time track because we really need to be done by about 20 after so we can reset for the council meeting, which will probably be lengthy as well. So if we don't get to everything tonight, you can always send an email to the law director with questions. So with no further ado, I will turn it over to the law director.
Thank you, Mayor. We sent out a PowerPoint, and hopefully you saw the material. In the last few months, there's been some periodically clarifications of how sunshine laws are interpreted. Perhaps the most relevant recent decision was last week. The Greene County Common Pleas Court issued a decision finding that the Bellbrook School Board of Education violated sunshine laws by using text messages and emails for round-robin discussions, and violated executive session by going into executive session with titles that were not permitted by law, and therefore discussing subject matter that was not entitled to be permitted or not entitled to be discussed in executive session. So it's my intention that Ben and I will go through these slides. My suggestion would be that if you have questions, perhaps you could just make a note, write your questions out, and then we could try to leave some time at the end. And as you've already heard, it is not our intention to get through the entire PowerPoint. It addresses some things that I don't think that we necessarily need to. So the first slide is just points everyone to.
Chris,
yes.
do you want me to share the PowerPoint though?
Sure, if you want. Yeah, that would be great.
Hold on just a
do
moment.
that.
Give me.
Yeah.
Okay, just tell me when to
Let's go to the next slide.
okay.
So the first slide just tells everybody where in the Ohio Revised Code the sections are that relate to Opens Meetings Acts, and then what is a public record. The critical component of 121.22 is subsection G, which includes what those limited number of topics are that are available for executive session. Ohio is considered to have some of the most transparent sunshine laws in the country. I think most of us would agree that that is a good thing. That also means that that creates significant impediments to private conversations, which then in turn leads sometimes to efforts to circumvent sunshine laws. Obviously, that is not a good thing for the reasons shown in the next slide, which is what happens if a sunshine law violation is found. While it doesn't happen very often, a public official, an elected official could, under certain circumstances, have personal liability. Now, I do want to, this is a good point where I think I can layer in something that is makes some sense, but it's not always intuitive. Whether a person is an employee, an elected official, or even on a board and commission as a volunteer, that individual is still a public official under Ohio law. And whether one likes it or not, and I'm not saying this in any way to discourage anyone from volunteering because it's not that big of an issue, but it's something that people need to understand. That title is a 24-hour title. It's not a you pick and choose. You can have conversations with people and be mindful of what hat you wear. This gets a little more sensitive for elected officials. But if someone is on a volunteer board, a planning commission, BZA, or whatever it might be, particularly planning and BZA, because they have deliberative components to them where they have people coming before them and who are asking for permission to do things. When an applicant comes to that individual and they're talking to the individual outside of the formal hearing process, that's where trouble could occur. And we'll get into that. So next slide, please. So in the event that there is some sunshine law violation, such as what happened here in Greene County, the court issued an injunction that required the board to not violate the law. There are also fines and court costs, and there will be an award of attorney's fees with that. Often the attorney's fees are the most significant punishment, depending on how long and hard the fight was. At least publicly, what's been reported is the attorney's fees in the Greene County case are somewhere in what appear to be the $3,000 to $5,000 range. I'll tell you, based on my experience, that seems somewhat low. Again, in the most egregious cases, in theory, it could lead to removal of office. I don't recall having seen that used in over a decade. What typically happens is that the individual office holder makes a decision that it is best that they resign, although that doesn't seem to be happening at the State House right now with an individual who's under federal indictment. Next slide, please. So the thing to keep in mind when it comes to what is a meeting, it's a prearranged gathering attended by a body of the majority members of the public body, arranged for the purpose of conducting, transacting, deliberating, or discussing public business. So in most situations, this is well known. We have agendas that we have to publish. We have to let the public know when these meetings are occurring. However, what happens in the new world of texting, social media, and emails is that the prearranged component doesn't have to require publication anymore. The mere fact that there is a communal email communication will then become the form of a prearranged gathering. Why? Because someone has to consciously say, I am going to communicate with these people. That becomes the prearranged gathering. The other thing that's important to keep in mind is that one cannot avoid the attended by a majority of members by simply saying, if there's a 5-member body and I only do 2, and then I do another 2 and I do another 1, and then I start to share what that information is, that's called a round robin meeting. And that is even a worse form of violation, because that clearly has a mental state behind it where someone is purposefully attempting to circumvent open meetings laws. Next slide, please, Jessica. So what is a record? Not all documents that are pushed into the public arena are public, remain public records. So for example, emails that memorialize the fact that we're going to have a Zoom meeting tonight, not a public record. Those are considered to be what's called transient records and can be destroyed immediately. All boards, commissions, offices of the public entity have a record retention schedule. There is a committee of the Records Retention Committee that is tasked with meeting periodically to review the records retention policy. One of the reasons, for example, that minutes of the bodies are so important is because that creates historical record by which generations later people can understand what was done and why. So for example, the former law director, Steve McHugh, has often told me a story of one time he had to go back to handwritten meeting minutes from the city of Oxford that were generated in the 1880s to try and determine the legislative history of the action that was taken by the then existing council over 100 years later. So I always tell people that keep in mind when you're drafting the minutes that you're doing it for a legitimate purpose, and that is really functionally to create the historical record of what's gone on in your community. And one can never know when that record could become of significant importance. So what I would say is that as it relates to what is a record, it's a record kept by a public office. It's stored in whatever medium. Back in the day, it used to be all paper. Now it's not. And it's how that document is kept and whether it is required to be kept is dictated by that public records policy. Now, I will also say something that's very, very important. If the records retention policy is not followed, in other words, there is not a routine and systematic purging of the files, if a record request is made and there are files that exist that otherwise should have been destroyed pursuant to policy, but have not been, they are a public record that must be produced. So it becomes very important that the offices that have responsibility for the public records that they keep, periodically make sure they're following their retention schedule. It becomes anyone who's responsible for the public records responses, and I think Ms. Eaton is, she can tell you that sometimes they can be very, very hard to get right, and that by having those records destroyed, it pursuant to law, it means we don't have to track down a lot of things to be certain that we've provided everything, because that's a legal obligation as well. Next slide, please. So now this is, I think everybody now recognizes that things that weren't always so obvious, like email when it was more of a novel form of communication, and now I would say text messages fall into that. Those are public records. And as we can, those of us who want to remember the last election cycle and the brouhaha that was created over about emails and what was on servers and what was not, it is essential, and I recommend in most cases, any elected official needs to maintain two emails, a private email and a public email. And if people use your private email, the way to stop your private email from becoming public is to forward those emails that are received on your private side to your public email account. And if you do that as a matter of course, then you can maintain some level of privacy. Just because you're an elected official doesn't mean you give up all of your privacy rights, but you do need to follow that protocol. If you find that the same is true with a text, what I would encourage you to do is to snap and take an image of that text and perhaps forward it to your public email as well. The fact that something is not a document doesn't change the fact, let me say it instead of a double negative, the mere fact that something is digital means that it can still be a public record, although it can be transient. If you have transient emails, I would encourage you to delete those emails. Transient emails would include, again, meeting notices, things that are informational only, that do not fall within a specific category of the records retention policy. Next slide, please. This case of White v. King is really the seminal case in this. If I'm remembering the case, Ben, correct me if I'm wrong, but I think that this case involved a state legislator who was asked to produce public records, and it was determined that her private email was not public because she had, or was not private because she had public information in it. And it simply reinforces the fact that the Ohio Supreme Court has ruled on this, and it's a losing proposition for someone to try to claim that their private email is private if there are public communications on there. Now, how that practically would work is if there were a lawsuit involving public records and there was a request for Jay Smith's Gmail account, and there was a belief that there were public records on that email, it's quite likely in that litigation that there could be efforts made to protect that email, but it would still be subject to, at a minimum, private judicial review to see if there were documents that were relevant to the public records request. So again, if everyone adopts the best practice, particularly elected officials and public employees, to move those emails received on private email chains to the public side, you'll be okay. Since I think we've got a number of board and commission members, what I would encourage board and commission members to do as a matter of course is to create a separate folder if you're using your private email, which most people would do. There's nothing inherently wrong with it for a board or commission because most of the things that they do, with the exception of Planning Commission and BZA, would not rise to the level of a requested document, although it could happen. So by keeping a folder, and that's being done in the ordinary course, and that folder would contain all the emails related to that board or commission, I think that that provides a layer of protection for the private side of that citizen's life. Next slide, please.
Hey, Chris, I've got a question from David. David, do you still have a
Sure.
question?
And this is just to add, because I know that there are litigious individuals in the community who tend to send me emails to my work email. And it does not seem accidental that they do that. So is there a strategy there that, I mean, I think we'll just follow your rule, but I know that there are litigious individuals who send
Yes.
things to my city.
What I would suggest that you do is CC your public email, provide a response to say, you are using my private email and work email to address a matter of public concern. In future, please send all correspondence through this email address.
Thank you.
And then obviously you've got something in the record. Okay. This next topic is a really important one. And this is really, in some ways, the most difficult part of how to figure out what hat an elected official wears, okay? And what I've seen is that, rightly so, that elected officials say that I have been elected by the public, I have an obligation to make myself available to the public, and that means on all subjects and all matters. And that's okay in general, except in communities where you have some aspects of council having to deliberate, either because it's a matter before council because your ordinances require it to go there. For example, rezoning, for example, things that go through your code. Council members who are on BZA or planning, which we have here in Oxford. So all of you have probably experienced the phenomena of an applicant. Sometimes they don't know. They don't understand that they can't just come up to the elected official because they're the elected official and say, hey, I want to talk to you about my application to get a variance or my thoughts on this development I want to do. If they want to give you thoughts on the development that you want to do, that's a little different because they haven't risen to the level of applicant necessarily. However, I think that you have to be very, very careful about where that subject's going to go, because that's what staff is there for. You have to count on staff to be the conduit to collect the information and funnel it to you. And if you do that, you won't be accused of ex parte communications. And sometimes you will find yourself in situations where you may begin to get a little uncomfortable because it didn't start out that way. Or a citizen who may not be an applicant says, boy, counselor, I have real concerns about this application and I see you're on BZA. That's where you have to find a way to politely say, the integrity of the process requires that I can't have a private conversation with you about this. Understand your concerns and respect them, but the protocol is that you need to put that information through staff. I assure you that it will get to the BZA and it will get to me in that forum. But that's the protocol that needs to be maintained because that's what the integrity of the system relies upon. and it protects the elected official from later claims of some type of ex parte communication, and it again maintains the integrity of the process. I'm going to stop there for a second because this is such a big deal, and it's sometimes counterintuitive to the hat that you wear as the elected official who has to think about policy, promoting legislative agendas. But it's different when you are on that body that either is doing some type of deliberation or is playing a quasi-judicial role for BZA, for example. And we've got some slides later on that we're going to get into the quasi-judicial role part of things. So I'll stop there and see if there's any questions.
Chris, can you just, I mean, you're going to have another slide, but the BZA is clearly quasi-judicial.
Yes.
How about conditional uses, PUDs? Are there any circumstances where in Ohio, is it really just a variance is the only quasi-judicial question?
Well, what I would say is anytime that BZA is deliberating on something, it is by definition quasi-judicial. Now, there's another category, and we're going to get to that, but there are two acts. There's a quasi-judicial, which is somebody determining the rights of one to use their property. And then there's an administrative side, which has to do with legislation. Typically, you see more of that in the Planning Commission. There are appeal rights versus, there's two types of appeals. There's Ohio Revised Code 119, which is a form of revised code appeal, administrative hearing appeal. And then there's a 2506 appeal, Ohio Revised Code, which is typically the quasi-judicial type of appeal. It gets very, very technical. Sometimes courts can't even understand it. I guess what I would say is that I want to explain the difference, but I don't want anybody to feel like they have to walk away from this knowing what the difference is. But I don't know if that answered your question, Councilor Firthridge. Okay. Next slide, please.
Chris, I've got a question from Councilor Ragu.
Sure.
Michelle?
So I didn't realize that public official also included employees or staff. Is that what you said?
Yes.
So how, with the ex parte communications, how can staff make recommendations for or against a project on behalf of a applicant?
Because they don't decide, they're only making a recommendation. And then, and that gets to the point that that Councilor Frithridge brought up. So for example, if the city's administrators, zoning administrators made a decision to deny a permit, that has appeal rights to it in the same way the BZA decision would have appeal rights. So there is legal recourse if somebody wants to object to a decision that's made. But the recommendation that you're referring to, Councilor Ragu, is where there's a recommendation to a body that is going to independently make a determination that may or may not agree with what the staff's recommendation is. So that's a process issue. Did I answer your question? Okay. So again, ex parte communications, I think that these are pretty self-evident. You know, again, the list is getting longer. Phone calls, letters, personal visits. Well, you know, 20 years ago, we weren't really talking about emails and texts. Certainly weren't talking about Facebook or social media. And now you've got Zoom and video platforms. So again, just be mindful. You know, most of the, in my experience, very rarely, I should say rarely, but most of the time, these situations can be managed with just a little bit of common sense application and understanding where the potential minefields are. And if you do feel that you're uncomfortable, I would always encourage the person to say you need to work through staff on that. And that's the safety valve. Next slide, please. All right, so this is the latest case that we had from last week. What ended up happening was that the Sugar Creek School Board for the city of Bellbrook was seeking to get on the ballot a fairly large levy, and if it didn't pass, there were going to be significant cuts in the district. Ultimately, the levy didn't pass. The state ex-rel, John M. Stafford is known to that community, and he, I think one could fairly say that he's got a reputation for being litigious. He made some public records requests. And that led to the disclosure of private emails and texts that the board was required to disclose by law. And those texts showed that they were deliberating. They were giving directions through those communications that on the surface were somewhat innocuous, which were, oh, I see that we're getting bad press on the local Facebook page. And they would say, well, we're going to have to do more to get the right information out there. And then the superintendent would issue a press release. Clearly, there was a cause and effect that led to the issuance of the press release that was based upon the private communications and the deliberations of the body, the school board, and that was being done outside the legal requirements that have public notice for the meeting, transparency, public have the right to attend. I don't want to belabor the point of what that says. We've provided you with a copy if you choose to read it. Frankly, from a lawyer's perspective, it's a fascinating read. Next slide, please. Again, more of what the case decided. I think that the key part is that second bullet point, that the public body must deliberate over public business at a meeting. The public is entitled to know what each one of you are thinking on that subject so that the public can understand how the individual's collective then became the collective act of the body. And that's an absolute right under Ohio's public meetings and law and sunshine law. And then I think the definition of deliberation was in there, and we can go on to the next slide. It's pretty straightforward in that sense. Let's see here.
Is that where you want to be? We're back.
Yeah, I mean, I just go on to point the remedy there was injunctive relief, and then assessed a civil forfeiture fine. That sounds more severe than it is, although it is a severe fine, which is, hey, you've got to pay money. You've got to pay money for the penalties, and in certain situations that could lead to personal liability. All right, next slide, please. So I'm going to have Ben talk a little bit about this. This is the next generation of public records litigation, which has to do with social media platforms. And this is another form of being mindful of elected official. You have your public persona and you have your private persona. If you want to maintain your private life, you have to intentionally divorce it from your public life. I can't emphasize that enough. And if you don't, you can find your private life being intruded upon in a way that, one, I think is partially unfair because you're still entitled to your own rights of privacy. But if it's not done properly, you in theory open up the door to potential interference with that. So Ben, I'll turn this over to you.
Thank you, Chris. Again, good evening, everyone. One other thing I want to mention about that Stafford City of Bellbrook decision, and I omitted a slide on this, but Chris already alluded to it early on in the presentation, but just something to be aware of before I move on to these other cases is another violation that was found as a part of that Stafford case was that the school board, before going into executive session, was not following Ohio Revised Code 121.22 subsection G. And by that, I mean the school board was not identifying why, one of the reasons enumerated, and it goes G1 through 8. So essentially there's 8 different reasons why you can go into executive session. Okay, so before you go into executive session, as a council member, as a commission member, as a board member, you need to identify one or potentially, I suppose, more of these reasons in 121.22 subsection G for why you're going into executive session. And the court really came down on the school board really for a technicality because the school board was saying personnel reasons, basically, when they were going into executive session. That's one example. That's not really a reason. The school board was also saying for evaluations, performance evaluations of public employees. That's really not a reason to go into executive session, so you have to be very specific. and Chris and I were talking about this earlier today, but, if you're going to executive session to discuss an employee's performance evaluation, because you are intending to terminate that employee because it's negative, or you're intending to demote that employee because it's negative, or you're intending to give that employee a raise, affect their compensation because it's positive, that's what you have to say. But it's not enough to say to discuss a performance evaluation. So be very mindful of why you're going into executive session, and ensure that you're announcing that reason on the record before you do so, because they were actually dinged for that. So that's that about that. I'll move on to the next set of cases. So the first bullet point discusses two lawsuits that you may have heard in the news. These actually were filed, I believe, last year in 2019, and these were against AOC. These lawsuits were alleging First Amendment violations for AOC blocking critics from her Twitter account. So her verified Twitter account, the one that we're familiar with, that she operates as a congresswoman. She was blocking critics from her Twitter account, and the reason that these lawsuits came to bear is because they were the result of lawsuits that were actually brought against President Trump, that you've most likely also become aware of, or you're familiar with. And that was really a landmark decision issued by the Court of Appeals, where it was called Knight Institute versus Trump. And the court came down on President Trump and said that the president engaged in unconstitutional viewpoint discrimination because the president was blocking critics from his Twitter account or Twitter feed. Next slide, please, Jessica. And here's really the takeaway from that landmark decision against President Trump. The First Amendment does not permit a public official who utilizes the social media accounts for all manner of official purposes to exclude persons from an otherwise open dialogue because they expressed views with which the official disagrees. So this is classic, what we would call viewpoint discrimination, or you're regulating who can express their views based upon their view, right? So if you're allowing people to comment on your Twitter feed or your Facebook accounts, you're allowing folks that agree with you to express their opinions and their comments and say, you've done a great job. I'm totally on board with how you feel about this particular issue, but you don't like the comments that disagree with you, and you block those. You're engaging in viewpoint discrimination because you're discriminating against, or you're regulating a particular viewpoint. Conversely, you're allowing another viewpoint for those that agree with you. Next slide, please. And, as an aside, you may have a question, well, what if this individual is engaging in comments that are offensive, they're laced with profanity, they're, engaging in personal attacks? There is some case law out there about that, and you can regulate that as long as it's viewpoint neutral. So, as long as you're regulating that because of the fact that it's laced with profanities, or because, those commenters or those critics are attacking somebody personally, that's okay. But you cannot regulate that solely because they disagree with you, okay? So there's a difference between viewpoint neutral regulation and viewpoint centric regulation. So here's another landmark case, and this actually kind of set the ground work for that Trump decision, that President Trump decision, and this is Brian Davison versus Phyllis Randall. This is a Fourth Circuit decision, and a public official blocked a critic from his Facebook page because of criticism. So again, this is not viewpoint neutral regulation, and the Court of Appeals held that the Facebook page had all the hallmarks of a public forum, and that blocking access was black letter viewpoint discrimination. Next slide, please. Okay, and here's the lessons from this, right? So you may have questions, you know, when is your Facebook account or when is your Twitter account a public forum? Okay, so once a public official opens a social media account and uses that account to interact in an official capacity with users, the account qualifies as a public forum under the First Amendment. And an official may not exclude users once it becomes a public forum under the First Amendment for their viewpoints. So, you know, some of you, for example, and this is true with a lot of public officials, may operate two separate accounts. You may operate a public account that you utilize perhaps when you're campaigning, or that you utilize to inform constituents of matters that are coming before City Council, and you only use it for that purpose. Well, that public official account, of course, is going to be a public forum because you have it out there for the purpose, for the reasons of interacting with the public, and you're explaining to the public what you're doing as a public official in your official capacity. On the flip side, you may have a private account, and that private account could be used by you for solely the purpose of maybe it existed prior to you being a public official, and you may just post on that account pictures of your family, things you're doing on the weekend unrelated to your public service. As long as you're not using that private account to do the same things that you're doing on your public account. So, you're not using that private account to also talk about, the agenda for a city council meeting on a particular evening, or you're not using that account to talk about the fact that perhaps, you're running again for election. As long as it's strictly and purely a private account, you're okay. Now, where we get into the muddy waters, right, is when you have a hybrid account, when you're using your private account to do more than just live out your private life. You're intermingling it with what you're doing as a public official. Once you start doing that, even if it's a private account and you also have a public account that's separate and distinct, you've really turned your private account into a public forum. And at that point, if you're engaging in communications with the public, with constituents, individuals who comment on your private account are entitled to First Amendment protections, and you cannot censor them or block them based upon their viewpoint. Okay, does that make sense? Is there any questions about that? That's kind of a tricky.
Well, I want to make a comment. This really gets into an area that hasn't been fully developed in the law, but I think we can see where it's going. We're coming up on a presidential election cycle. When I go onto Facebook infrequently, I see many posts for or against certain candidates. And as an elected official, I think you have to be really careful about engaging in that form of political discussion on a Facebook platform, because you could unwittingly turn it into a public forum, even though it's about national politics or statewide politics. I don't have a good answer for you what that litmus test is, but again, that's the burden that I think comes with the obligations that an elected official holds. So anyway, back to you, Ben. If there's, we've only got a few more minutes, Ben, so
Okay.
you might want to go quickly through the next one.
Perfect. I will go super quick. This one is really, this is also a relatively recent case. This is a Sixth Circuit case. This actually came out in August of 2020, so just last month, less than a month ago. This discusses what is considered a matter of public concern and protected free speech, and what is solely a matter of private concern. So I don't want to read this statement here. You all probably read this, but this is a post that I've quoted here from the decision that a Cleveland EMS captain posted on his private Facebook page. He had it turned to the private setting, but this is a post that he posted about obviously the Tamir Rice shooting that happened in Cleveland a while back that we're all familiar with. It's a highly offensive, highly incendiary post. I think we'd all agree with that. I think the court agreed with that. That's that post there. Jessica, you can go to the next slide, please. So the question is that protected speech, right? You know, and the court grappled with this question, and the takeaway here is, and this employee was terminated and he sued. He said that this was a free speech situation and that he should not have been fired for what he said. And the court looked to see whether this speech was a matter of public concern. If it's a matter of public concern, it's entitled to First Amendment protections. If it's a matter of solely private concern, it does not have the same First Amendment protections that a matter of public concern has. If it's a matter of public concern, there's an additional prong to the test where the court balances the interest of the employer against the employee to see whether the employee's free speech interests outweigh the efficiency interest of the government employer. Next slide, please. So here's the test for whether your speech is a matter of public concern. If it's a okay, and I think this is, next slide, please. I'm sorry. Here we go. It's a matter of public concern if the comments directly relate to a subject of general interest and of value and concern to the public. And the court actually determined, perhaps shockingly, but using this standard, that employee's comments were a matter of public concern because that individual was commenting on a well-documented shooting that was already at that time and largely still is obviously in the public's mind. It's in the public discussion and it's a matter to everyone. So the court said expressions of opinion, even distasteful ones, do not become matters of personal interest simply because they are phrased in the first person or reflect a personal desire. Next slide, please. So the court decided that speech was a matter of public concern. The court did not rule on whether Mr. Marquette's free speech interest outweighed the interest of the city of Cleveland in the efficient administration of its duties. This was just remanded back to the lower court. The lower court's going to make a decision about that. The lower court may very well say that, they're going to do the balancing test, right? And they may very well say that, Mr. Marquette's interest doesn't outweigh the city's interest in having employees that are not expressing racist, offensive views, but that's going to be for the lower court to decide. The court only decided that his speech was a matter of public concern. So this really gets into whether you can discipline an employee for their free speech and whether or not it's protected. Next slide, please. And Chris, I think you want me to turn it back to you at this point?
Yes, I think I've got about 5 minutes, and so I'll get through this pretty quickly. Even though this is in some ways probably the most likely area where someone could find themselves in potential trouble, which has to do with Ohio's conflict of interest laws. All right, so the first side really can just summarily be talked about Larry Householder. He used his is alleged to have used his political position to obtain money for his own personal use, and then is being accused of feathering that money around to obtain an outcome. I don't think that anyone needs any explanation on why that's wrong and you can't do it under the law. However, the application of conflict of interest laws by the Ethics Commission and the investigations that come from that sometimes can be far more subtle. The two examples that I'm going to use, because Oxford has so many Miami employees, in 2018, Steve McHugh obtained an ethics opinion. I provided that to you. The upshot of that is, I think on anything that relates to Miami University, any counselor who is employed by the university needs to ask the question, is this something I can participate in? In that ethics opinion, there was an arrangement between the city and the university to do public works improvements on the roadways, even though those are public roads. My understanding is are maintained and dedicated to the city, but there's contractual arrangements that flow from that. The decision from the Ethics Committee said when there are contracts between, and this is slide 27, Jessica, we can just fast forward to that. When there are contracts between the two public agencies, a public official or employee is prohibited from having a fiduciary or financial fiduciary interest in the contracts. And I think the way you can look at that is it can be direct or indirect. Obviously, no one who's working for the university, unless you, I guess, suppose you're in public works or somehow affiliated in that department, would have a direct benefit, but there's clearly an indirect benefit because of the value that the university as a whole receives. So I think that everybody can track that. Another area when it comes to potential conflicts of interest has to do with, and this really now goes to, let's see where this is. The idea of, is this general impact or limited impact? So if the city is contemplating building a new water plant, then all councilors could vote on that because that is a facility of general concern. However, if there is a discussion about whether or not there needs to be potentially a new water main put in a specific area and only a few citizens would benefit from that, and you happen to live by that in that area, that would arguably be a matter of personal concern to that neighborhood. Therefore, that might require recusal. So I'm going to give you an example that is going to come up tonight. I was actually somewhat surprised by this. When I was working on lodging tax legislation in another community, this was a smaller community, and they had about 35 to 37 what we would classify generically as Airbnb type of establishments. And we considered the implementation of a lodging tax and lodging tax ordinances to regulate Airbnb to be a matter of general overall concern to the entire community, because it wasn't being restricted. The use wasn't being restricted to any location. So I got a verbal from the Ethics Commission that said that was that they did not see an issue. One of the council members wanted a written opinion. When I got the written opinion back, the Ethics Commission did a reversal and said because there was such a small number of Airbnb establishments and 2 council members were involved in that business, they determined that it was too small of a percentage and didn't reach the umbrella of the entire community. And therefore they determined, the Ethics Commission determined there was a conflict of interest. So I share that. I don't know if anyone on this council is engaged in the business, but I think for purposes of the upcoming legislation that might be grounds to one to recuse him or herself from that discussion for that reason, because it really becomes a numerical calculation, and I don't have the power to make that determination. I think it would require an individual opinion from the Ethics Commission on that issue. The last thing I'm going to talk about is on, let's see here. We don't need to talk about Robert's rules because you have Counselor Snavely, and he will make sure that we follow Robert's rules at all times in all circumstances, which is a good thing. Okay, I would like to look at slide 34, please. This is going to be my last comment. Keep going.
The page numbers went away, but.
Oh, okay. It says disclose a conflict, and it says
Right, is it?
abstention versus recusal.
There
There we go. Okay. So while we commonly have seen in other legislative bodies and on occasion here that people might abstain, abstention is not an appropriate act if there is no basis for it. In other words, if a person does not want to vote on a piece of legislation and there's no conflict of interest that requires recusal, there really isn't a grounds to abstain, because an abstention becomes functionally a no vote. So there are very, very few circumstances when abstention is appropriate. I struggle to even think of one in a municipal setting. I've never looked at this, but I suspect in the rules of procedure for the U.S. Congress, they probably have provisions in those rules that allow for an abstention. I'm not aware of any rules within our charter or our code which would allow a counselor to abstain absent a conflict of interest, which would require recusal, at which point abstention would not be the appropriate path. It would be to say, I recuse myself, which means I'm not participating, as opposed to abstention, which means I'm choosing not to vote. So with that, I will stop. And if there's any questions, we can answer some.
I have a question. Is that all right, Mike?
Yeah, go ahead. I saw your hand first.
Okay. So on Planning Commission, we have on more than one occasion had a situation where one of the commissioners just couldn't decide. They saw points on both sides. The vote was up. They didn't know what they really wanted to do, so they just abstained. So now tell me, as chair of the Planning Commission, what I'm supposed to do at that point.
I think that the process that I would recommend would be to say that in the absence of a conflict of interest, there is not a procedural rule that allows for abstention. It's a procedure issue. Now, that may not get you to the right place, but that's the best answer I can give you.
So the person then has to say yes or no.
It goes with the oath of the office, yes.
Okay. Well, that's news. That part is news to me. So thank you for sharing.
What doesn't happen very often, but what tends to happen is it comes in cycles. Somebody says, well, this person abstained, so that must be something I can do, when the rules of procedure don't allow that. If the city of Oxford wanted to allow abstentions, you could build that into the rules of procedure. You have the power to do that, I believe.
Thank you.
All right, I saw Councilor Ragu's hand next. Let's try to hurry, please.
Thanks for the presentation. This is really good information. And I have a question, and correct me if I mischaracterize it, Jessica, but just at the last Police Oversight Committee, they were talking about having a way to have kind of an email so that it would go to the whole committee. But then it was mentioned that if anyone on the committee, that no one on the committee could respond to this complaint, because then it would be violating sunshine laws. So I'm just wondering, is that true? Could they not respond to an individual person who's trying to complain?
That was the confusion. And so I asked Ben for a formal opinion, which we haven't gotten that yet, but that was like, how do we do this? So I don't know if you're ready to share your answer yet, Ben, but.
And I'm still looking into it, let me turn off my fan, I apologize. And that is something I'm looking into still, and I apologize for the delay on that. But I would certainly say it goes back to the discussion that we were having before about whether the comments that the official is providing constitute deliberation or not. So you don't want to get into this deliberation into the substance if it's a matter that needs to be a public record under the Open Meetings Act. If you're, confirming receipts, you're saying thank you, you say great, thanks for sharing. That really doesn't constitute deliberation. Chris, I don't know if you have anything to add to that.
No, I agree with that, and I think that this is where I've got to understand the process better. So I'm not ready to weigh in specifically, but conceptually, that's why staff is there. Staff might be able to be the source for that, but we will give you the formal opinion on how to deal with the situation. And I think that the other thing that we have to be mindful of is just because we might be able to do something a certain way doesn't mean that we should, particularly when it is something as sensitive as police community relations and how those types of complaints and those issues are being processed. So that's the best answer I can give right now.
All right. Again, I've got some other questions, but I'm sorry, I've got to cut us off so we can get set for the council meeting. But if you want to email those to the law director, he'll share them with an answer to all of us. Thanks for that presentation. I learned several things tonight that I wrote down. So let me see here. I think I need a motion to,
And if I could just say one thing, it is always better to err on the side of asking the question. Please ask the question. No harm will come of it, and an ounce of protection.
I move we adjourn the work session.
all right, second. Second for Mr. Prithrick. Ms. Eaton, will you call the roll so we can adjourn?
Mr. Ellerby? Mr. Prithridge?
Yes.
Ms. Ragu?
Yes.
Mr. Snavely?
Yes.
Ms. Southard?
Yes.
Mr. Bracken?
Yes.
Mr. Ellerby?
Yes.
Mayor Smith?
Yes. All right. I'll see everybody at the council meeting.
Okay, I'm gonna stop the live stream, rename it as a city council meeting, and then we'll be ready to go again. So give me just a second, please.